Welcome to CBIA's HR Hotline Live. I'm Diane Mokriski, Employment Counsel at CBIA. At our last hotline, we discussed hiring practices. So today we thought it fitting to focus on the other end of the spectrum and discuss the pitfalls that can come up with employee terminations. So we'll talk about the concept of at-will employment, what that really means in real life, as they say, and we'll give some practical guidance on things like termination meetings, termination letters, if you should use them, what they should say, things like unemployment, and all the questions that come in. So this is a hotline webinar, and so that means that rather than presenting slides, we'll be focusing on the questions that come in from the audience. We did receive some questions in advance, and so we'll address those as well. Please submit your questions through the Q&A function. And when we're finished, CBIA will send out a recording of the webinar to everyone who registered. So I'm joined today by two partners from Carmody, Torrance, Sandak, and Hennessey, Nick Zaino and Vincent Farisello, both of whom have extensive expertise in all things employment law. And I know many of you rely on them outside of these webinars, so we're very lucky and happy to have them with us today. So hi, Vincent. Hi, Nick.
Hey, Diane.
Thank you.
So let's start, as I mentioned, the concept of at-will employment. And one of the first questions that came in advance was, how do you terminate someone when it's just not working out? Like, what can we just say, well, it's at-will employment? So what do you both say to that?
So I'll start, and then Nick, feel free to jump in as well. But obviously, most folks on this call know that Connecticut is in fact an at-will employment state. So that means absent an agreement otherwise, whether that agreement is in writing or verbal, but absent an agreement otherwise, either the employer or the employee can terminate that relationship at any time, with or without cause and with or without notice. In other words, for any reason or no reason whatsoever, except what I like to say, except for an illegal reason. And so there are a ton of statutory protections, even common law limits to the at-will employment standard. So for example, we're all well aware that both federal and state law have strict prohibitions against unlawful discrimination or harassment. There are laws that protect against retaliation for exercise of protected rights, things like complaining about harassment or discrimination, protections for protected whistleblowing activity. And then there's a host of other common law type protections against wrongful termination. So it's great that we have at-will employment in Connecticut, but from a legal standpoint, yeah, you don't necessarily need a reason. But from a practical standpoint, I think you need to be able to articulate that reason in order to defend against a claim if one is brought for something like wrongful termination or discriminatory termination. And so, it's a question we get all the time from our clients. And oftentimes I'll get lots of details about it. But I often have conversations with our clients who are thinking about terminating the employment of an individual. I often will start with a question of, why don't you tell me in 1 to 3 sentences what this is about? Is this performance related? Does this have to do with misconduct? Is there a rule violation here? And I ask that because I want the client to be able to articulate for me, but also so later we can articulate to a third party if we need to, like a judge or an arbitrator or whatever, why we took this action. Again, it's not because we legally need to do that. It's more so that we're in a better position to defend against a claim should one come later.
Okay. Nick, do you have anything to add to that before we get into the specifics? There are more specifics.
Yeah, I mean, not really. I mean, we can go on and on, but I think as we get through some of the specifics, we can, flesh out some more reasons why it's important to have good reasons for a termination and good supporting reasons in documentation. So
yeah. All right. So then let's talk about a related question that came in, and it had to do with the question is, we've got someone whose attitude brings down an entire department. And so we really want to let them go, but they've had glowing performance reviews up until now. But that was maybe a prior manager, and so now this person is really a problem, and now we really just want to let them go. But it's at will, right? So let's say that person called you. What would be some of the things that you would talk to them about?
Yeah, so we would want to know a little bit more about the situation, of course. We would want to know, who is this employee? When did they start working for you? And sort of how long have they been working for you? That's not necessarily a protected basis, but certainly employees who are considered longer term employees, you would expect a little more due process, a little more progressive discipline involved before you took an employment action than you might somebody who's been employed for a very short period of time. So we would want to know what their role is, how long they've been employed. We want to know any protected characteristics that they might have, any recent red flags that have come up. They're returning from any kind of job protected leave or made any internal complaints that might be protected. We, of course, want to know what they're doing that is rubbing people the wrong way, or how they're acting in a way that is considered misconduct. Is it objective? Is it subjective things? We want to know if it's been documented. We want to know how you've treated other employees in the past. Like, all these questions are questions that we have sort of a mental checklist in our head to try to gauge, how to approach it. Do you have sufficient grounds to terminate the employee without the employee putting forth a good argument that it's on some illegal basis? And just want to know that, is this a story that makes sense? Does it seem like you treated the employee fairly? That's kind of what our approach should be. And I think that should be your approach too. If you're in HR with your managers and your supervisors, you want to go through sort of that same vetting process.
Okay. So you mentioned progressive discipline. That's not required, right?
Right.
But you're talking about defending against something. And so how would you, so let's say we have this scenario where someone's got glowing reviews so far, but it is problematic now. So would you tell them, okay, so start documenting?
Yeah, I mean, here's the thing to remember. So most cases where an employee challenges a termination decision on the grounds that it's illegal, most of them involve discrimination claims. Usually they're complaints filed with the CHRO where somebody claims the real reason they were terminated from employment is because of a protected category, right? And nobody can get inside the employer's head, right? Most cases don't involve the employer overtly saying, you're too old, we need to end your employment, right? That's clearly age discrimination. That usually doesn't happen. And so all you're left with are circumstantial evidence. Why was the person terminated? And you look at the whole picture. Maybe they were the oldest employee in the workforce. Maybe they're an employee who just returned from job protected leave, and there is no progressive discipline. There's no warnings. In fact, the file is actually pretty good, or there's nothing there until the person went on this protected leave, right? And so now the employer is telling you, or a manager is telling you, they have a really bad attitude, right? That creates risk, because in somebody's mind, the real reason might be this leave or this other job protected incident that's happened as the real reason. So progressive discipline that's steady, that's fair, that's accurate, that shows that the employer is trying to address a performance issue, absent sort of serious misconduct, that puts you in a much better stead in defending a case than if you don't have any.
Okay, so you mentioned people coming back from job protected leave, and that was another question that came in. And this is so common. I'm sure you get this. I hear this all the time, which is, oh, we were just about to fire this person. We were just about to do it. And then they went on FMLA. So
Yeah.
now we didn't fire them while they're on FMLA. Now they're back. And now we want to fire them. So, and you, Nick, mentioned, well, I won't put words in your mouth. So let's say you have that scenario. So what are you going to say to that employer?
Well, we've said it both ways. There are times when the employer can establish that, in fact, they were going to terminate that person's employment, but for the leave, right? So I would want to know from that employer, is that documented? Can we prove that? Can we establish that that decision was made? You know, are there internal emails? Did you draft a, you know, a termination notice if you use that within your organization? You know, did you have any, can we prove it? Is it diary? Is it calendared? And then the person went on leave? And if the answer is yes, like the decision was made and it's a solid decision based on legitimate reasons, well documented, then yes, I think you can go ahead and terminate that employee's employment. Again, if it's only in their head, right, and nobody knew that they were going to be terminated, no one, it wasn't, you can't prove it, then it looks suspicious to terminate someone right when they're coming back from leave or right soon after they come back from leave. Because again, nobody can get in your head. And so you've got to be able to prove that in some way.
Yet another example of why, you know, documentation winds up becoming so important in these cases. And you know, Nick, you were talking about documentation, and it kind of goes two ways too, because if you know you want to have things documented, that really helps. That can be a huge help to support a story of sustained poor performance or you know, rules violations or whatever it is. But you know, one caution I would always, you know, I always say when we're talking about documentation is don't go too far with it, because you know, overdoing it or, you know, having this, you know, long 10-year history of a ton of documentation and no real consequences to it kind of sends a different message of maybe that kind of conduct was actually tolerable and wasn't so bad. And so then it begs the question of, okay, so then what changed that we had to change course after a bunch of years of this? So, you know, again, the point is documentation is important, but doing it right is even more important.
So Nick, what's probably the next most common question I get is, okay, well then how long do I have to wait? The person came back from FMLA. So how long? A month?
Right.
2 months?
We get that question all the time. And then we
Yeah.
also get, you know, how much documentation do you need? Right. Like, so just to piggyback first on Vincent's point, which is a good one, you know, while documentation is important, getting it right is equally important. And if you start papering the file, right, the person goes on leave, they never had any disciplinary issues, they come back and suddenly there's a big pile of paperwork about, you know, warning, 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 counseling. That's not going to help your case either. It looks like you're papering the file to set up a termination. So there is no answer to how much time do you have to wait. It's based on the facts and circumstances. It's based on what the person did, you know, that was inappropriate. It's based on their performance. It's based on legitimate documentation of performance issues. And so there is no time frame. Like it's got to be based on facts and circumstances.
Okay. Okay, so we talked about documentation, coming back from protected leave. Let's move into, oh, actually let's talk about a question that just came in from Sarah. Most of the time, the reasons managers want to terminate is weak. How can you help them strengthen it? So my reaction to that is, well, that seems, what's the word I want to use there? Like that seems like that motive is fishy. Why are you trying to strengthen? Like it's all about motive. The motive has got to be legal. So what would you say to that? The reason is weak. So how are you going to strengthen? It's got to be truthful, right?
Right. I play devil's advocate with
Yeah.
the supervisor. I really push and prod, and I have found that, you know, oftentimes playing a little bit of devil's advocate with that individual, and then putting it in the context of, let's see how this would play out to someone who has nothing to do with your business, who has nothing to do with you, doesn't know how that business operates. How would this sound to that other person? And I found, yeah, obviously that doesn't work all the time with a supervisor who is very intent on making that type of a move, but a lot of times it does give them some pause to get them to start thinking. And then, to be very frank with you, it comes back to, again, what we've been talking about with regard to you know, how can we prove how that's a problem, you know, whether it be through documentation? How can we show that this is business related, this is a necessary move? But I think you can't forget to look at, have we taken similar actions with others in the past? is this consistent with what we've been, with our track record, or is this a departure from that? And it could be okay. There are times it's okay to want to change course or to set a new type of precedent, but I want to certainly know how this squares with what we've done in the past and what we want to kind of be the standard going forward.
Mhm. Okay, so let's move on to, let's say you've decided, okay, we're going to do it. We're going to terminate someone. Should we use a termination letter? First, let's do this. Are termination letters required?
No,
No.
the short answer to that is no. There's nothing that says thou must provide a letter of termination to an employee, or that you need to put in writing necessarily the reasons for the decision to the employee. Having said that, though, I would say as part of the unemployment compensation laws, there is a requirement that an employer immediately provide to a terminated employee a separation packet. Used to be known as a pink slip. They're not pink anymore, but a separation packet, which includes a separation notice, used to be called, it's available on the Department of Labor's website, used to be called UC 61. Now it's called UC 21. And it provides just very basic information for employees about the process for applying for unemployment benefits. And there is a section where the employer is compelled to pick a reason for the termination, but it's kind of a checkbox thing. Aside from that, though, there is no other obligation to provide an internal termination notice to employees. If you do choose to document or to provide or to put in writing internally the reason for the termination or a notice per se, then there is an obligation to provide that document to the employee within a day. That rule comes from the Personnel Files Act. It doesn't require that you create a document, just if you do create the document that you give it to the employee. And then beyond that, the employee should always have the right to rebut that if they so choose. They do have that right under that same statute. Frankly, if you are going to be using termination notices or even any kind of disciplinary notice or performance evaluations, you should have a little disclaimer on there. I believe it's required by that statute that the employee does have, notifying the employee that they have the right to rebut the statement and have that included with their file. Doesn't mean you have to change your mind or change anything, but just that they have the right to rebut or and keep that in their file.
Okay, so before we move on to the nuts and bolts on the termination letter itself, if CBIA could post in the chat a link to the separation packet, you can find that. If you were to Google Connecticut Department of Labor unemployment separation packet, you'd find it, but we'll put that in the chat. So if we talk about, let's say you do decide to issue, or let's say someone calls you and they say, okay, we're gonna terminate someone. We're thinking about giving them a letter explaining why they're terminated. How do you decide whether to issue that letter or not? What are some of the factors you think about?
I mean, here's what I will say. I generally recommend some letter be given to the employee communicating that their employment is terminated, right? Typically, I would recommend a simple letter that refers back to a conversation, because I think the decision to terminate somebody, the communication of that should be done preferably in person, face to face, right? And there are circumstances where that's not possible nor advisable, but generally it should be communicated, one human being to the other in person. Then the letter can simply refer back to that meeting. So this letter confirms our discussion today or yesterday. Your employment with the company shall end effective blank. Like, I usually don't even use the word is terminated. Your employment is over or end, or your separation of employment date is X. And then you go on to things like COBRA and unemployment and return of company property and all the other kind of nuts and bolts of sort of ending the employment relationship. Sometimes the employer will want to include the reasons, which can be okay, right? They can be okay. You can certainly include the reasons and you can detail why that termination decision is made. And sometimes it makes sense to do that. Maybe the file is light and, you want to be clear in your communication to the employee and then maybe to their attorney. If you think that the employee is shopping this and thinks that something bad happened, you want to be able to put your reasons out there so that an attorney looking at this case who may ask for the personnel file and not see much in the file will at least have a termination letter that details the reasons why that person was terminated from their employment. The only caveat there, and it's a big one, is you need to be accurate and you need to state it broadly enough that you cover all the reasons. Because if you say it's due to X and then later you're in litigation or you're filing a CHRO or an EOC response and you say it's X plus Y plus Z, invariably you say, well, where did Y and Z come from? The termination letter only said X. And so it can be done in a termination letter. It just needs to be done carefully, completely and well said.
Okay.
So.
Ben, you want to add anything to that?
Well, I'm looking at one of the questions that in my mind is a little bit related to the last point Nick just made. And the question was, all of our terminations are marked as layoff, even when we have a cause. We don't fight unemployment. Can this be problematic, particularly if we then hire another employee for that position? The writer of that question is not alone. That's something I hear frequently. And I often caution against it because, it's kind of, I understand the desire to do it. It's kind of the path of least resistance. It's not confrontational. The hope is that this is the easiest path for us to go forward. But on the off chance that there is a claim made, this calls into question when you're in defense mode. This kind of calls into question both, your trustworthiness as an employer, how truthful are you going to be? If you're now going to say later, no, it really wasn't a layoff. It was really because this employee was a terrible performer or violated this rule and that rule. But you on some paperwork marked something different, that kind of impacts your credibility when you are then trying to defend that claim later. So I think that's a problem. And that's why I think it's, I often caution against just doing that blanket approach. I think it's, also just fair to tell people what it is that's happening. And frankly, that goes throughout the whole process, not just at termination. That communication should be happening throughout employment. If someone doesn't know that there's a problem, you've never given them an opportunity to correct it, which I think is kind of inherently unfair in and of itself.
Yeah, so I think that when the employer just marks everybody as layoff, the intent there is to be generous, right? We're just going to say layoff so that they'll get unemployment, when the fact is that they're probably going to get unemployment anyway. Even if you say discharge, the odds are they're going to get unemployment. So would one of you like to talk about what's the exception to that? There is a way to avoid unemployment liability, willful misconduct. Can you talk a little bit about that? What is that standard? It would be, I think a lot of people call it cause, like just cause. This person deserved to be fired. A lot of times, even if you deserve to be fired, you get unemployment. But what's the exception to that?
Well, so I'll just speak very generally, and then you could let me know if I've answered the question or not. But the idea is that an employee, the theory behind unemployment is that if someone is unemployed through no fault of their own, that's what the benefit is there for. And so you get into this idea of, so what's through no fault of their own? Well, things that would disqualify them from benefits, of course, is if they quit voluntarily, right? If they quit voluntarily, theoretically, that's not through no fault of their own. They shouldn't be eligible for benefits. An exception to that is if, they voluntarily quit, but they did so with good cause attributable to the employer. And what does that mean? Something like the employer unilaterally changed their hours or their pay or working conditions in such a in a material way. That could be an exception to the no voluntary quit rule. But also if the employee is discharged for that concept, you referred to it, willful misconduct in the course of their employment, and that could take a bunch of different forms. That could be, deliberate misconduct. I'm kind of trying to think of the phrase exactly that's used in the unemployment context. It's deliberate misconduct and willful disregard of the employer's interests. So that's knowingly doing things within your employment that are against the employer's interests. That could include, rules violations or taking actions deliberately that would negatively impact the employer. It does not mean poor performance. If someone is let go due to poor performance, that is generally something that would make them eligible for benefits. Other things that could disqualify them: a single knowing violation of a reasonable and uniformly enforced rule or policy. And again, that's where documentation is going to become very important. You want to be able to document the rule, that it was communicated, the employee was aware of it, and then document how that employee violated that rule. Also, certain absences without good cause. I think the standard is 3 separate absences without good cause within and without notice to the employer within a 12-month period could make the individual disqualified. Also, if they engage in felony behavior or larceny in the course of their employment, things like that. Those are the standards to meet for someone to be deemed disqualified for unemployment benefits. But you've alluded to it, Diane. It's often it winds up because in that context, it's the employer's burden to meet that standard. And frankly, it's been my experience that it's a difficult standard to meet, but it can be done.
Mm-hmm. I find that it's a very difficult standard to meet at that first level with the administrator, but if you want to spend the time and money appealing, you might win on appeal. But I mean,
Right.
who wants to do that? Is usually the thing.
Well, yeah, I mean,
Yeah.
it begs there is a cost benefit analysis to be done too. Most private employers, for-profit employers are generally paying unemployment tax based on their experience rating, but there's a maximum percentage to that, right? So if you're already at the maximum, there may be less economic incentive to fight unemployment. But if you're at the lower end and every penny counts, there might be some more economic benefit for fighting it. But it's not just the tax burden, it's also the cost, the administrative cost, potential legal costs, or other third-party that providers out there who provide unemployment services that come at a cost. The other thing to think about is there the potential for other litigation? And then how would this on the record dispute with the employee at unemployment positively or perhaps negatively impact the potential for future litigation? There are times where I've worked with clients and we have made strategic decisions to fight unemployment, to get an individual on the record under oath, locked into some type of testimony, and that's been a strategic decision. I've also seen other situations, and Nick and I were talking about one earlier today, where if things go wrong at that unemployment hearing, that could negatively impact subsequent litigation. Or other time, and then I'd say a third factor to think about. And you're never going to have a magic. There's no magic crystal ball to know the answer to this. But I always ask the question is there a likelihood that if this individual is able to collect unemployment, there's a higher likelihood they're just going to go on with their life, move on, and be less likely to think about bringing some claim or suit against the employer? It's not a perfect answer, but because I've seen some situations where I do believe that fighting it, poking that bear, has caused some employees to think more about bringing a claim against the employer.
Okay. And Kim asked, we were talking about the separation packet and the pink slip. The employer is supposed to do that even when people resign. Okay.
Yes, that's correct.
Okay. So no matter why someone leaves employment, when they do, you should give them that pink slip, which, as you said, isn't pink.
Not pink anymore. I don't know if long before my time, it might have
Yeah.
been pink. But yeah.
So another question that came in advance was, can terminations be done through electronic means if the employee doesn't show up to work and won't answer their phone? And the tricky thing with that, I mean, I guess they obviously mean their personal email address, I guess, because actually, maybe I'm presuming that, but I don't know. What do you say to that? If you can't even get a hold of the person that you're trying to terminate, what do you do then?
Think you try the different pieces of personal contact information you might have. If you don't have a personal email, maybe it's a mailing address. Maybe it's,
Yeah.
you know,
I'm sorry to interrupt. I was just
that's
thinking,
good.
I think maybe the statute or the regulation technically says that you're supposed to put the pink slip in the mail. Do you remember that?
I don't know that offhand.
So I mean, I think mail is a good idea in any event.
Well,
But what were
and
you gonna
even
say?
outside the context of the pink slip, just any term notice of, we're ending your employment. Somehow, I
Mhm.
mean, if you can't get in touch with the person any other way, all you have left is whatever other modes of contact you have for that employee. Again, personal email, home address, perhaps even last ditch, by text using a cell phone. None of these are ideal, like in one of Nick's prior comments talking about ideally you're having these conversations in person, but again, not always possible. So I might even think about if you're going to if you're going to send it hard copy, snail mail, maybe think about, not necessary, but think about using certified mail, or maybe
Mhm.
FedEx or UPS. Little, a very modest additional cost, but at least you might have some proof that you sent it.
Mhm. Okay.
Yeah, what I'd add to that, I would also put in the letter something along the lines of, I've been attempting to contact you, over the past whatever, unfortunately we haven't been able to, you haven't returned my call, whatever it might be, but show in your letter or your email, if it's got to be done electronically, that you've made attempts to try to arrange a meeting, and they just didn't return your call, or respond when you wanted to set up a meeting.
Okay. All right, I'm going to move on to a question from Cheryl. And we've touched on this a little bit, but so it sounds like this is going to be, it starts, I have an employee that's been unhappy with someone and has complained about him. And they think that they resolved it, but he's not a good fit. Can I terminate him? So what do you say to that? I guess this is going to be a potential retaliation claim, retaliation for complaining. So the answer is going to be yes, probably, but what type of documentation, or how would you have them handle that?
Well, I mean, it's hard to answer this in a vacuum. We would
Yeah.
want to know a lot more information about, what is the issue? Why have they not gotten along? Maybe it's not the fault of the employee that you're looking to terminate, but maybe it's the other employee. What have you done to address it? Have you spoken with both? Why are you selecting this individual to be terminated? Have they had conflicts with other employees? How have you handled it in the past? How long has this person been? Or sounds like they've only been there for a brief period, right? I think in the question. In any
I
event,
don't know that that's true, but yeah, I think what you're saying makes sense. I mean, there's
yeah,
there's so much
yeah,
background to
yeah,
that,
yeah,
right?
yeah. There's a lot more
So
info you need.
yeah, whistleblower protection. Can you talk a little bit about that? Like what is an actual whistleblower in the state of Connecticut, and how does that different from just someone who complains?
Yeah. So anytime an employee is complaining or raising concerns about something that they reasonably believe might be illegal, unlawful, against public policy, that is generally protected. either under a whistleblower statute or for, protected against wrongful termination for raising what they believe are good faith concerns about wrongdoing or something that violates public policy, even if they're wrong, right? Even if the employer can establish, no, you're wrong about that. The law allows employees to make these complaints, to raise these concerns in good faith, even if they end up being wrong. So that would be something that an employer should consider to be protected under the law and not take action against that. That differs from the employee who complains just about everything, just about things that have nothing to do with public policy, nothing to do with about laws or compliance. In those situations, those complaints are not protected complaints. So,
Okay. Let's move on to a question that we got in advance, and it has to do with companies going out of business. So if you are gonna terminate everybody, what are some of the concerns to be aware of there?
I think the biggest thing that comes to my mind when I hear that a business is going to go out of business or shut down or have a big, huge layoff is whether this federal law called the WARN Act comes into play. So hopefully most folks have heard of the WARN Act. If not, it's a federal law that basically requires that in the case of a plant closing or a mass layoff, and I'll get into what those mean in just a minute, that before those happen, the affected employees must be provided 60 days advance notice of termination in one of those contexts. And number two, that the employer provide certain notification to the chief elected official in the town in which the plant closing or mass layoff is happening, and also to the dislocated worker unit of the State Department of Labor, if there is one. So what does it mean when we talk about a plant closing or a mass layoff? A plant closing is the permanent shutdown, or actually could be temporary shutdown, permanent or temporary shutdown that results in an employment loss of at least 50 employees during a 30-day period at either a single site of employment or facilities or operating units within a single site of employment. Okay, so just think of it as we shut down and 50 or more employees will lose their job as a result of it. Think of it that way in terms of plant closing. A mass layoff is a reduction in force that results in employment loss at a single site of employment during a 30-day period of at least of either 50 employees who comprise at least 33% of the active employees at that workplace, or a mass layoff that impacts 500 or more employees. So in those two contexts, if there's a plant closing or a mass layoff, as I've just defined them, then WARN Act could be something that the employer should be thinking about and thinking about in advance, because there is that 60-day notice period that's required. Now, I should have started at the outset. So which employers would be covered? Because not all employers are covered by WARN Act. Covered employers are generally applies to larger employers, but it's any employer with 100 or more employees, excluding part-timers, or 100 or more employees, including part-timers who collectively work at least 4,000 hours each week, excluding overtime. If you are out there and you think a mass layoff or a plant closing is on the horizon, don't rely solely on our conversation here to determine if you're covered or whether it's a covered plant closing or mass layoff. Really important to talk to someone like Diane or employment counsel to make sure you have your ducks in a row, because if you miss that deadline, you can still be on the hook for pay in lieu of notice.
Okay. Yeah, that's a very specific type of employer, which I'm guessing we don't have a ton of those on this call, but yeah, since there are such specific requirements, probably contact a lawyer if you're gonna do that. So we talked about, I just want to go back for 1 second. We were talking about pink slips and things you have to give an employee when you're going to let them go. We didn't talk about final paychecks. Nick, can you just let us know, what is the rule for final paychecks? When do you have to give those?
Yeah, in a nutshell, on an involuntary termination, you have to give it within the next business day. And if the person resigns, then you have to give it by the next pay period. So,
Okay. All
and
right,
this
so
is the other one, the layoffs or reductions in force, it's by the next pay period. So,
okay. So we got a question in about severance. Would you recommend offering severance and having someone sign a document saying that they won't dispute the termination, like a release? So this is going to have to be, I know you need the facts in each scenario. What are some of the things you think about and that you talk about with your clients when they ask you that question? Like, should we ask them to sign a release, and should we give them money? What are some of the things you ask them?
yeah. So I think severance, like if you are an employer who has an existing severance plan and it falls within the reasons for termination fall within the severance plan, then you have to offer severance pursuant to the terms of your plan. And so a lot of large employers have severance pay plans that are ERISA plans. And I will tell you, I think severance pay plans can be a huge risk mitigator for employers. And that's why a lot of larger companies have them. But they come at a cost, of course. Usually for smaller employers, it's done on a case by case basis. Um, and, we want to know what the practice is of that employer, with regard to severance, what have they done in the past in offering severance and how have they calculated the amount. Um, some employers will only offer severance if the person's terminated for reasons that they don't deem to be cause. Maybe they're eliminating the position or reducing the workforce, and so they're going to give severance. But in some cases, even if you've got an employee who has had performance issues, offering severance is a good way to mitigate risk, especially if they're a longer term employee, and they're having performance issues, but giving them something versus nothing, makes that employee have to think hard. Do I want to file a lawsuit and pursue that? Or do I take this severance or maybe try to negotiate a little bit higher amount of the severance? And a lot of times, you're able to negotiate or they accept the severance that's being offered. So, whether to get a release, generally yes, unless the amount that's being offered is so small that it raises more of a red flag than it's worth. Like you're offering, a week of severance. I'm not sure you need to go the distance and have them sign a formal release, but you could. It's 1 week of severance that you're not obligated to pay. So, those are
Do
some
you think, can
considerations.
I interrupt there? Do
Yeah.
you think that a week of pay is enough consideration? Is that enough to make that release valid?
Yeah. Any consideration that is not sham
Yeah.
consideration, right? Something that's not, it's not something you're already obligated to give. Courts typically don't get involved in determining whether it's enough. We just sort of look at it and we say, okay, look, we're going to give them a document that looks like a legal document, and it's going to have all these, you waive and you release, and in exchange for that, you're giving them 1 week. Does that release agreement just push them to see a lawyer in exchange for 1 week, or do you just roll the dice, give them a week, and cross your fingers? Like so, when some employers are comfortable just giving the week without getting a release, and some don't want to pay that week unless they know they're getting, some waiver and release.
Okay. Ben, do you have anything to add to that?
Nick alluded to it, risks that I think about or, things that I consider when thinking about offering severance, just be mindful of what message, if you like, I'm a fan of offering severance in exchange for a waiver and release. I think that goes a long way. They're never ironclad. They're never 100% perfect. You can't, I have had very few, but several situations where someone has signed one and brought a claim anyway, but those are few and far between. I think they are very effective in terms of mitigating risk. But don't just think they're appropriate all the time. Sometimes you have to ask yourself, what does this raise a red flag? Does this give an appearance that does it make it look like we think we did something wrong, or does it imply that we're in some kind of weak position? I also will ask if you're talking about a situation of serious misconduct, does offering severance, is that consistent with the story for why we are letting that person go? If they did something really bad, If it's as bad as you say it is, why are you offering severance? So they're just things to think about more often than not. I think they provide some pretty good risk mitigation.
Okay. There was an anonymous question asking about FMLA and doctor's notes and can we let them go? I'm going to say if you're a CBIA member, if you want to email me that question, that's not really covered quite with this webinar. If you're not a member, you can give Nick and Vincent a call.
Can I interrupt you for 1 sec? Just one other point I think we should definitely make, because I've on severance before we totally change gears. If you are going to be offering severance, just note that the form of that document may be different depending on the age of the employee. You may want it to be different based on the age of the employee, and that's because federal age discrimination law requires that for a waiver and release to be effective as to older employees, a bunch of different requirements need to be included in the severance agreement, including a certain period of time for the employee to review the agreement, and then also an opportunity for them to change their mind. And there's a bunch of other requirements as well, but it might be why, if you've ever done a severance agreement and worked with counsel on it, they might have asked, is the person 40 years old or not? Because we want, if they are, we want that, and we're going to ask for a waiver and release, and we want it to be effective as to age claims. We want to make sure that we have all of those bells and whistles in that document.
Yeah, I mean, if you're going to do a severance agreement, I really would recommend that you have a lawyer do that. There are so many ways that you're going to get in trouble, and it is not going to be enforceable if you mess that up. So I do want to talk about I want to talk a little bit about return of property and security. So have that in mind. But before we get to that, can we just, Nick or Vin, there was a question about the unemployment and the 3 separate instances. Can you give an example of how 3 separate instances of absence apply and how to document it? Yeah, can you just address that?
Yeah, and my recollection is the rule changed on this, used to be a little bit more complicated, but what we're talking about here is essentially someone who's, absent. I think that the phrasing in the reg is absent without good cause or without notice for 3 separate instances within a 12-month period. So what you're essentially talking about here is a no call, no show. That's really, I mean, in a lot of ways, I mean, more times than not, that's what you're talking about. And you could have a no call, no show if if there's good reason for it, like the person was in a car accident and is in the hospital, that might be good cause. So, they're not, you have to do some investigating before you just think that it's a golden ticket to avoid unemployment liability. But there used to be a more complicated formula for, consecutive days might get grouped and count as only one instance. It was always troubling for employers, and a couple years ago that changed. So each day of no call, no show, or not showing up without good cause and without notice, each day counts as a separate instance. And so 3 of them within a 12-month period doesn't, let's remember, let's not lose the forest for the trees. We're talking about for unemployment purposes.
Right.
That
not
doesn't
whether
mean,
or not you can fire.
Right. You can certainly still fire somebody outside of these strictures without violating a law, but it just might mean that they might be eligible for unemployment, but that doesn't mean you're not allowed to do it. So I just want to set that we're just talking about for purposes of unemployment qualification.
Okay. So Nick, if we talk briefly about post-termination matters, so let's say we're talking about returning a laptop. Like, what do you do? Don't you get this question all the time? We fired somebody, his laptop is at home, and now he's not contacting us. What's the best way to handle that? How do you handle security, IT security, stuff like that? Is that in the termination letter, or what do you recommend for that?
Well, so you should have a policy or a practice on how you do that. And typically, if you're going to terminate somebody in person, the best time to get your company property is right then and there, right? So typically, you would contact your IT department. right before you're about to do the termination meeting, let IT know that they have to cut off access to the company system so the person can't later, after they've been terminated, try to go back onto the computer system. You want to try to get that laptop back right then and there at that meeting, or the company phone, or documents, or files, or keys, or passwords, thumb drives, whatever they may have. The best time to get it is in that meeting face to face. Sometimes it makes sense to allow the employee to gather their belongings at that time as well. And sometimes what you say to the employee is, we will pack it and we will ship it to your home, or arrange for some other time for you to come pick it up if it's going to create, some sort of scene at work, or, concern about the employee sort of traipsing through the workplace and saying things or doing things that are going to be disruptive. If for some reason you can't collect the company property at that meeting, typically what the employer will do is they will send a box, prepaid postage, label that the employee can use, box up and send back, and the employer will pay for it, FedEx, UPS, whatever. But here's a prepaid label that they can just put on a box, put all the stuff in there, and it has to be returned. Sometimes the employee doesn't do that. We have to send letters, or we start with a nice letter from the employer, then we escalate that with our letters and so forth. But that's why it's better to get it on the spot if you can. So
What about,
sometimes, yeah.
I was gonna throw a sort of a little twist on it. Can you deduct the value of unreturned property from that final paycheck?
Not without DRL authorization. So no, you can't. So they may leave with your laptop and you can't hold that final paycheck. And so that's a good question. We get that too, and that may really, that may really strike employers as being unfair. And in many circumstances it is, but that's what the law says. So
doesn't mean there aren't other avenues
yeah.
for trying to get it back, just not, particularly palatable ones.
Yeah.
But one other approach could be, if you are someone who's doing severance, offering severance is, adding that as a condition to receive severance is
Yeah.
certification that you got everything back and whatnot.
So when you mention there are other avenues, we're talking about a small claims.
Yeah, that's one. That's one of
Yeah.
them.
Right.
I've had some employers who have actually even contacted local police departments with very different, seen responses to that all over the place, from being very helpful to being not helpful at all.
All right, so a question came in about PIPs. I know some people think, if you're giving a PIP, you're basically just setting someone up to be fired. That's one view.
Yeah.
If we're talking about getting ready, I mean, in theory, a PIP is meant to improve performance, right? So is there ever a time when a PIP is a bad idea, or do you always say, yeah, do one? What's your view on that?
PIP is a bad idea if it's not genuine. There's not a
Exactly.
genuine plan to improve performance. And it's being used as another step in a progressive discipline process. Generally, a PIP is not a good idea. Or, PIPs usually aren't great for misconduct sort of things, like somebody who is, engaging in misconduct. That doesn't feel like the kind of thing where a PIP is appropriate. So a PIP needs to be genuine and real, because many plaintiffs' lawyers believe it's the kiss of death and it's all a pretext. It's not real. The benchmarks for achieving, satisfactory PIP at the end are unrealistic. The time period is too quick, and it's just sort of a tool that's used to terminate somebody's employment. And so in that case, a PIP is not a good idea. So you have to use it in good faith, where you believe the person, if they do certain things, they can turn this around. And if that's not the case, there's misconduct, then just go the traditional progressive discipline route, or if it's at the point of termination, just terminate.
And ask yourself, if they meet the benchmarks, are you going to be okay with them staying? I mean, that's part
Right.
of the same analysis.
Right.
Yeah.
And so
Careful
I
what you
think
wish
it's
for,
just
right?
more to Nick's point. Like I'm a firm believer that performance management, and I think PIP is one of many different pieces of performance management. I'm just a firm believer that to do it right, it's got to be with an eye for giving someone the knowledge of what they're doing wrong and the tools for fixing it, and giving them an honest to goodness chance to improve and get better. And I think that's not just fair for the employee, but it also gives the employer the best shot of getting a good, productive employee to be successful. Doesn't always work though.
All right, this is probably going to be the last question, and it's the last one on the Q&A. Our organization provides a generous PTO policy, but we're facing challenges with employees who appear to misuse it. If an employee is frequently absent for reasons not covered under protected leave, can we lawfully terminate their employment before they've exhausted their accrued PTO? It's like, do we have to let them use their PTO, or can we let them go?
Yeah, so so let's just give an extreme example. Let's assume that you give 20 days of PTO and the person's hired in January and they've blown through 18 days of PTO in 6 weeks, right? So they have 2 days of PTO left and they've blown through 18 days over a 6-week period. Can you terminate? And the reasons for their absence are not job protected. Is that excessive absenteeism? Yes, right? And so, yes, I think that can form the basis of disciplinary action or termination of employment. If they, but it's the rare case that that's the case. And so you just want to take a hard look, is it excessive absenteeism? Are there others who've had similar rates of attendance issues for non-protected type leaves? Like, are you being consistent in how you're handling this person? So the short answer is yes, to that. Like, you don't have to allow the employee to use all PTO days that you give them before you can take disciplinary action. If those days are being used excessively in a compressed period, that could be the basis for disciplinary action or termination.
I'm gonna fight back on you on that one.
All right, fight.
So what if the policy though just said there's no rules about how soon you can use the PTO? You get 20 days. You don't have to spread. The policy doesn't say you have to spread it out over 6 months. It just says use it. You've got 20 days. So they use 20. Is that really excessive? I would say that's not, clearly it's not, because you gave it to them.
Yeah, no, it's a good
What do you
point.
say to that?
Now I'm giving you an extreme example, right? They're
Yeah.
using 20 days over a 6-week or 18 days over a 6-week period. That's a lot. And then
Yeah.
they're using it for not coming in, just nilly-willy reasons. And so I think an employer in that situation could say, look, we mean to give you 20 days spread out over a year, not over 18 days. And so unless you've created through your policy some sort of contract, implied contract expectation that you won't take any action as long as they stay within that period. But I agree with you. You do want to look at the policy and see how it's worded.
Maybe, I mean, it would be as simple as saying you can only use PTO with prior approval, right? Or like, I mean, if someone's giving them permission all along,
right.
take it.
Yeah, good point. Right.
Yeah.
Yeah.
All right, we actually still have a couple of minutes, so I'm going to try to do this one with Brenda. We hired an employee back in May. They've only worked 3 weeks. They got hurt outside of work. They haven't returned. Their communication's been non-existent. We reached out last week, didn't hear back for 3 consecutive days, and made the decision to terminate. But before we could send out the letter, this is always the thing, they replied to the original message, and now they're maybe explaining why they were absent. So I guess it depends what they said. The reason is that they were
Yeah,
absent.
I was just going to say, I'd love to know what was the content of their finally when they responded. I mean,
Yeah.
but from a legal standpoint, it doesn't appear that FMLA would be an issue. Certainly not under federal, not under Connecticut. They've only been there they've only been employed for 3 weeks. Doesn't look like it's a workers' comp related thing because it happened outside of work. You know, is there the potential to provide some unpaid leave under ADA or Connecticut's anti-discrimination laws? Maybe it depends. You'd have to get into a whole analysis of, what kind of impact, hardship, undue hardship, if any, that would have on the employer. But without knowing some more facts and knowing what the reason, why they were incommunicado for all that period of time, you very well could be fine to terminate, subject to, what the story is. If we find out, if you find out that the reason they were unable to get in touch with you is because they were completely incapacitated for some period of time, well, I think that might be a mitigating factor, and you might want to at least think about, at least reconsider. Doesn't mean you have to change your mind, but at least, think about it a little bit more.
Okay. All right, so we have run out of time. Great questions, everyone. And like I mentioned earlier, if you're a CBIA member and we didn't get to your question, particularly there was a fair number of FMLA questions in there. And I know someone at CBIA who loves FMLA questions, Del Marina Lopez. It's her favorite thing. So if you have a question about Connecticut FMLA or paid sick leave, feel free to email us and email Vincent and Nick. Thanks very much again for joining us, and we'll see you next time. We do these quarterly, so everyone keep your eye out for the next one, which will likely be in December, which I haven't told these guys yet, but that's probably when the next one is.
We'll look forward to it either way.
Okay. All right, thanks everyone, and have a great afternoon.
Thank
See
you.
ya.
Bye-bye.
Bye.